related rights. He is currently a senior legal counsel at the Kenya Copyright Board, KECOBO. He has over 5 years experience in copyright infringement prosecution and has successfully litigated several cases on copyright and related issues in Kenya. He's also a member of the Law Society of Kenya and the East Africa Mediation Training Institute. He holds a master's degree in intellectual property from the African University in Mutare, Zimbabwe, and an LLB degree from Kampala International University, and a postgraduate diploma in law from the Kenya School of Law. So karibu sana Muturi, karibu sana Kaindo, and thank you to all our guests who are joining us across the country and across the world. So just for a feel of who would be in the room, before I hand over to Sami, we have people from Zambia, we have people from Kenya, we have people from the US, we have people from the UK, we have guests from Nigeria, we have guests from Ghana, and I hope the list will go on and on as we continue. So we're privileged to be in this space and to have you guys today. So Sami, we'll start off with you. You will be enlightening us today on legal aspects of mobile applications. So specification with data protection regulations. So you could just dive into it and our audience would be ready to hear from you. Sami, I'll just request you to unmute your microphone. Thank you. All right.
Thank you, Mona, for giving me this opportunity to share with the participants about the data protection regulations and also to enlighten them on the legal aspects concerning data protection in the mobile applications. Just to dive into what we are talking about data protection, all this comes from the right to privacy, which is protected by the Kenyan Constitution 2010, where under Article 31, every person has a right to privacy, which includes the right not to have their person, home, or property searched, their possession seized. What is critical here is subsection C of Article 31, which provides that every person has a right to information relating to their family or private affairs unnecessarily required or revealed, and every person has a right not to have the privacy of their communications breached. Pursuant to that right, under Article 31, you will recall that there was a Data Protection Act of 2019, which was enacted on 11th of November 2019. And this is the Data Protection Act of 2019, which specifically is an act of parliament which gives effect that Article 31C and D of the Constitution, which principally establishes the office of the Data Protection Commissioner to make for the provisions for the regulations of the processing of personal data and to provide for the rights of data subjects and obligations of the data controller and the processors and for the connected purposes. For the ease of understanding what we want to tackle today, a data you all understand means information which is processed either through equipment which operate automatically in response to instructions given for that purpose. That includes the mobile applications and any other information which is recorded with the intention that it should be processed by means of such equipment and is recorded as part of relevant filing system, so that any data which is processed and collected in mobile apps is data in accordance with this act. And for an entity to process such data, there are certain principles which they need to take into consideration. There are principally 6 principles which anyone who is running a mobile app should conform to. One of the principles is that business processes that handle personal data must be designed and built with consideration of the principle and provide safeguard to protect the data. That is well provided for under Section 41 of that Data Protection Act, which provides principally that any data controller, and a data controller here or a data processor is the person who is holding that data, shall implement appropriate technical and organizational measures which are designed to implement the data protection principles in an effective manner and to integrate necessary safeguards for that purpose into the processing, so that such person should only use personal data which is necessary for each specific purpose, and I should process that data in consideration with the relevant data protection principles. The other principle which mobile applications should take into consideration even when developing is that data should not be publicly available by default and cannot be used to identify a subject. That is key because the right to privacy provides that information relating to any person should not be readily available. And if such data is shared with any person, should not be able to identify that subject easily. The data subject is the owner of the data, and they are given that right to hold data and to have a say as to when that data should be shared with third parties or even with the data processors, and given a right to say or even to request for deletion of such data. So the other principle is that no data should be processed unless with the consent of the parties. And the consent of the parties is very well defined in the Act. The consent must be unequivocal, it must be free, it must be specific, and it must be so clear that the data subject wants that information and data shared in that application. But how about a child? If the data subject is a child, the best interest consideration of a child is taken into account. And such data should only be shared with if it is safe and if it is in the best interest of that child, where now the parent or the guardian needs to give that consent. Therefore, when the mobile application is being designed, the developers needs basically to put such information which should provide that the age of consent for that data subject is also provided for under the application, so that the person who is logging in can state whether they consent or they don't consent, whether they are adults, whether they are people of minority age. The other way the data should be processed is only through contract. And this presupposes, of course, this consent. And one of the things the mobile application developers do is to provide for accept all, you don't accept, or you decline. So when you're logging in into an application, therefore, that presupposes there's a contract that whatever data you're going to enter into that application, you have consented into it through that contract, which provides also the terms and conditions of use of that application. And it takes you through so many issues about terms and conditions of use of that application. So the other way the data should be processed is if there's a public task, which brings the issue of public interest. That does not need a lot of explanation. And if the greater public interest will be safeguarded by sharing that data, then that is allowable under the law. The other way that data can be shared is where there's vital interest of the data subject, where there's a legitimate interest of the data subjects, and that there's a legal requirement that that data should actually be shared with the person who they are sharing that data with. So the other way the data should be processed, it's where it is used for historical purposes, for statistics, for journalistic purposes, for art or science or research. The fourth principle for data protection regulation is that processing of data should be voluntary by the data subject, and that being so, then the data subject can actually request that such data can be revoked from the system at any time. It can be erased, or they can request that such data should also be rectified. That therefore means that the data subject reserves the right to control that data and to say when that data should stay within the system, whether a mobile application or the web, so that that right to privacy is also safeguarded. So under the Act, it establishes an Office of Data Protection Officer, which basically provides that the data protection officer is in charge of controlling the data. And basically, when it comes to big data being collected by big organizations, then it requires that there be an impact assessment on the data, where the data protection officer will basically assess whether this data is relevant, it is for the purpose for which it is being sought, whether it complies with the consent which the data subject has given, and whether the rights, the individual rights of the data subject outweighs the purpose for which that data is being collected. So that if those safeguards are not safeguarded, then the data protection officer can actually enforce the act, and it becomes criminal basically to share data which the data subjects have not consented to. Further, as a data collector, you are supposed to report any breaches of system within 72 hours. So the duty to protect data within the system is with the data collector and the data processor. So that if there is that breach, the duty of care falls now on the data processor, and damages can accrue in court for breach of that data protection. And the law recognizes that technology is very fluid and that innovation is continuous, and it requires that every data that is to be stored must be protected, so that there's a greater requirement that the data processor or the controller should basically protect the data from being hacked or being people coming from hacking the system and taking away the data. And
Okay.
also at the end of once the data is the purpose for which the data is collected, then the data processor is supposed to discard that data, and to discuss to do away with that data, then it must be done in a reasonable way, protective way, in a way that it protects all those principles of data protection.
Okay, thank you, Muturi. If I could jump in. So in this space, there's usually a lot of companies complaining about infringement on rights, especially when it comes to driver verification. You know, if I could use the example of Uber, ourselves here at Ngamia, and when people are asked, you know, we need to verify your identity. So you probably would have to put up selfies or something like this. How does this also tie to security issues and the data you're talking about? So if you could tell us very quickly before we go to kind
Very well,
of.
Mona.
Yes.
As the person who has collected that data, you have the consent basically from the person who inputs that data for the driver in the application. But when it comes to giving it to third parties, you can only give it with consent. And if you have to share with it, you need to anonymize. And if it's for the purpose for which it was collected, then it should not be easily identified. When you share that data, it should not be easily identifiable with the subject, the data subject.
Okay, which then would also. Okay,
the
sorry, go ahead.
principle of consent and privacy must always be observed.
Okay, which then would mean that in this case, we have to sensitize and possibly ask people to adhere to the terms and conditions, because it's usually a very fine print. Hardly many of us usually read these things. So I think then the purpose here would be able to encourage people to go through the terms and conditions of use, because then this is what would be used against them by whichever company it is that would be offering this kind of data to different people, right?
Very well, Mona. And that is why when the developers are developing the apps, there's always the aspect of terms and conditions, which incorporates the user privacy, and there's also the privacy policy, which you need to assure that the users of that application, that whatever data they put in that application belongs to them and nobody else, and that they have a right even to request for the deletion of any erroneous information or completely remove it from the system. That is a right which belongs to the users of that application.
Okay, thank you for that, Muturi. I think before this, not many people knew even the definition of data. So thank you very much for your insight and your input. So for businesses in transport and logistics industry, obviously with a link to technological innovations, it's important to establish business relationships with other entities, contracts, monitor compliance, regulatory and industry standards. But it's also very important to invest in protecting intellectual property. So I want to hand over this discussion to Paul. Paul from Kekobo, and he is going to be speaking to us in a few minutes about the role of Kekobo in protecting intellectual properties and what are the kind of rights that are extended to technology or innovative companies from your end, being from Kenya Copyright Board. I know there's a lot of people here who do not know the difference between copyright, between trademark, between trade secrets and all these things. So hopefully at the end of your 15-minute speech, we'd be able to go home with something. Yeah. So over to you, Paul.
Thank you, Mona. Now, in 15 minutes, I hope I'll be able to demystify the distinctions between all those. Now, thank you, Akili. Nice to see you. Now, I'll delve in the interest of time, and start by saying that intellectual property is simply intended to protect the creations of the mind. And we have different kinds of intellectual property. We have, generally they are classified into two. We do have the industrial property, and then we have copyright. So copyright is part of intellectual property, and then we have industrial property. And industrial property includes patents, and patents are intended to protect the industry, the new innovations that are industrially applicable. So if you come up with something new that has never existed before, then we say you can actually get a patent over it. Then we also have trademarks. A trademark is intended to distinguish the goods and services of one creator of that particular product with another. So if, for example, you have Safaricom, that trademark Safaricom, the way it is, it identifies the products of Safaricom as belonging to Safaricom. So it is intended to distinguish products of one company and another. Then we have industrial designs. Industrial designs are intended to protect the visual appeal of the product. The shape of the product, like the shape of the Coca-Cola bottle, is protected under industrial design. Now, those three are the main one. Of course, we have others, which I don't intend to talk about now. The geographical indications are the others. Are protected, are provided for under the Industrial Property Act, and they are under the purview of the the KIPI, Kenya Industrial Property Institute. Then we have copyright. And I'm sure the main question that people would be asking, but we are talking about technology here. How does copyright come in, considering that technology deals with the scientific knowledge for practical purposes, practical use to solve problems? Why is the practicality in copyright? Now, you'll agree with me that such sciences, technology in itself, includes, among other things, ICT, information communication technology. At the backbone of majority of the technologies is computer programs. Like Wakili have said, in most of these technologies, you'll find that behind them, there is computer programs. In the 20th century, we have seen the computer programs growing exponentially. And computer programs have played and continue to play an integral part in technology. And they are the backbone of mobile apps, such as, of course, the one that Ngamia uses in the transport industry. And of course, of computer software. So of course, we have other areas where mobile applications and computer programs are being used. May it be in health, may it be in education, and maybe in other critical areas. While initially it wasn't clear whether and to what extent copyright law may protect protect computer programs, it is now sorted that computer programs represented either in the form of source codes or object code formats should be protected as literary works within the meaning of the Berne Convention. So there is no dispute that computer programs should actually be protected under copyright as literary work. In fact, when you look at the Kenya Copyright Act, I'm very aware that we have participants from across the world, but I'm going to concentrate on the Kenyan law. I'm sure they have an interest finding out the Kenyan law. Section 2 of the Kenya Copyright Act defines literary works to include computer programs in compliance of the Berne Convention, and they are eligible. Literary works are eligible for copyright under Section 22 of the Kenya Copyright Act. Now, what does copyright protect when it comes to computer programs? First of all, copyright grants exclusive rights to creators of original creations of the mind, which are expressed in a tangible format. There are keywords there. We have exclusive rights, then we have original creations, and then expressed in tangible form. Now, exclusivity here means that the creator has the exclusive right to use and authorize the certain use of his or her copyright. So he can decide to license or not to license, or to sell, to distribute, or to deal with them as he wishes, or to prevent others from exercising those rights that he has. Of course, the use of these rights is limited by the second schedule of the Act, which provides for the exemptions and limitation. There are some things that you can do, you not being the copyright owner, but then will not be deemed to have infringed. Those are provided for under the exemptions and limitations in the second schedule. Now, when you talk about, I'm going to put a section there. There is, when it comes to computer programs, there is a provision that, I don't know whether I have shared. Have I shared? I'm not sure whether I've shared a screen.
Yes, you have. Yes, you have, kind of. Thank you.
So that should be, just a minute. These are the exemptions. I hope you can see they're provided under the second schedule of the Act. So you can use somebody else's copyright work as long as therefore they fit within those general exemptions. But when we come to copyright works, to computer programs, there are exemptions which are provided for under Section 26A. These are things, I'm not going to go through them, but I'm sure you can see them in your screen. These are things that you are allowed to do, you not being the copyright owner, but then you not be deemed to have infringed on the rights of the copyright owner. Now, so these are the exemptions, and then Section 26A, when you are dealing with computer programs, keep in mind the exemptions and limitations. Together is Section 26A. Now, unlike patents, copyright does not protect ideas, does not protect concepts, procedures, mathematical formulas, and operational methods. There is something that we call the idea expression dichotomy, meaning that copyright is intended to protect the expression of the idea, but not the idea itself. So in that case, for example, I'm going to use the app for Ngamia. This is an app that connects transporters and customers generally. There is nothing that prevents me from coming up with the same idea, but expressing it differently. So what is protected for Ngamia is the way they have expressed that specific idea. So the way I express it, as long as it is sufficiently original, will be protected. So nobody can reproduce the way I have expressed this. So again, unlike patents or trademarks, copyright does not have specific formalities and is protected once it is expressed in a tangible form that I have mentioned. You have to express the idea. The idea has to be in a fixed format for it to qualify for copyright. So if you just have an idea in your mind, and it is not expressed in any way, that is not protected. Now, other than being expressed in a tangible form, the work has to be original. Original here, unlike in patent, does not mean new. It does not mean novel. It means that, one, it is not copied. You have to prove that it's not copied. And sufficient effort has been expended in making the work to give it an original character. So those are the basic principles on copyright. It has not been reproduced from an existing work. And then at least you expended some skill and creativity in creating the work. Now, what is protected by copyright in computer programs is the source code and interface, including the artwork, as long as they are sufficiently original. However, do realize that there are some other intellectual property areas that can actually protect some aspects of computer programs, such as trademarks. You said if you have an app that uses like Ngamia, that design that is up there, the camel, that is a trademark. I'm not sure that is registered at a KIPI, but it is protected as soon as it is registered. If it is not registered, then it is not protected. It is not protected. Now, I mentioned that the copyright holder has exclusive rights. Now, these exclusive rights are provided for under Section 26, and I'm going to attempt to share that Section 26 because I don't intend to go into details. Section 26 provides for these rights. So if you can look at Section 26, provides for the right of reproduction. Then there's a right to reproduce, distribute to the public by way of sale, communicate to the public, making available, as well as to broadcast. Those are the exclusive rights of the copyright holder. So it is only him who can authorize authorize those actions. And we call these rights economic rights, and they can be transferred either by license, by assignment, or testamentary disposition. Then somebody might ask, but then we do have open source where people do all those things. People reproduce without getting recourse from the copyright owner, they adapt, they distribute. Now, open source is a form of a license in itself. So it is these open source softwares. There are softwares for which the original source code is made freely available and may be redistributed and modified according to the requirements of the user within certain confines. So look at the open source applications or softwares. You can reproduce, but then you must also make them available under the same terms. You can develop, you can basically develop them, and then you have to share them under the same terms. So open source is in itself a form of a license where me as a computer programmer, I choose to make it available freely. Now, who owns these rights I've mentioned? Who owns these exclusive rights? Now, the first ownership of copyright rests in the author. So who is the author in relation to computer programs? An author in relation to a computer program means the person who exercises control over the making of the program. That is Section 2, the definition of an author. The person who exercises control over the making of the program. So if I'm a company, I have employees who are making these computer programs, then me, the company, is the one exercising the control. Now, the other, notwithstanding that, where a program is commissioned by a person, okay, if I exceed, just alert me by saying something. I can't see the chat.
No, it's fine. I think you have about 3 minutes. That's fine, so that we have some time we have some Q&A coming in. But just go ahead. Go ahead and finish.
Now, where the program is commissioned by a person who is not the author, who is not the author's employer, we always say that that work now belongs to the person who has commissioned. Now, what about when you are dealing with an employee? When you are dealing with an employee who is under a contract of service, any work that any copyright for that matter that they create belongs to the employer. Of course, you know that copyright can also be co-owned, and you can have partnerships. In the absence of an agreement, then the idea is that they equally hold the rights in that work. Now, the term of protection for copyright is 50 years after the end of the death of the year the author dies. If it is a company, then it is 50 years from the end of the year in which the work was published. Now, in the case of infringement, in case there are infringements, the right holder has a role in monitoring their work. And once they realize that, they can take advantage of Section 35B that provides for the takedown notices. Of course, the remedies includes criminal sanctions, civil remedies, and the like. Now, Kekobo, what is the role of Kekobo? Kekobo, one, is a state corporation that is mandated with protection of copyright. And among the things that they do is enforcement. They're allowed to enforce the copyright laws. We also do what we call ADR, alternative dispute resolution. We also do trainings. We train for free. We don't even charge for the same. I would have put a slide there, but I think I'm getting too difficult. Now, they also provide a registration system at the nrr.copyright.go.ke, and there is no need to disclose the source code, so you can take advantage of both copyright and trade secrets. I would have talked more about the trade secrets if time allowed, but unfortunately, Okello tells me my time is up. Thank you.
Kind of, maybe just in the interest of the public and the audience that is here today, just touch a little bit on trade secrets. Because I think it's one of the questions that had come up. One of them was, does IP protection have a limit? I think you've answered that and said 50 years, the end of the company or the individual. And then the other question was that, trade secrets. Yeah, how important is that? What do we need to do in terms of contractual agreements and partnerships? What would that look like?
Trade secrets, actually, according to me, is one of the best way that you can be able to protect your computer applications. Because of course, the source code being the way it is, unless somebody sees, in most of the cases it is, unless a person sees it, that is when they can be able to reproduce. So a trade secret is where you keep that source code secret. And to do that, you need to have, need certain clauses in your employment contracts. If you have employees, you need to put clauses that require them that they will not disclose these matters. They will not disclose anything that comes to their knowledge when they are in employment. And also, of course, these are the non-disclosure agreements. Now, why do I think that trade secrets are the best? Now, one, remember I've said that copyright is limited. It's limited for 50 years. That means once 50 years end, if it is a company, then it falls into public domain. Anybody can use it. It doesn't need to come to you. But assume that you have a trade secret. This source code is secret. Nobody knows about it. You continue enjoying it even after the term of protection has come to an end. So maybe you can use it together with copyright for purposes of what we call time stamping, such that if trade secret fails, then you can hold on to copyrighted. Like I said, when you're registering, unless it has changed, you don't need to disclose your source code when you're doing the registration, unless that has changed, which I had the time. I've talked more about it.
Then there's one more question, kind of for you, from one of our participants, Paul Nzengu Nzeveka. Thank you for your question. He's asking, is registration necessarily important to prove ownership, or can you use the work also, can use of the work also be adequate to prove ownership? So it's a case of use versus the actual registration. So maybe you could respond to that.
Thank you, Zegu. I know Zegu is in the US.
Yes.
I sort of know him. Now, copyright is not mandatory. I know in the US, I am aware that for you to be able to get certain remedies, the statutory damages, your work must have been registered. Now, in our situation, copyright registration is not mandatory. It is voluntary. So you don't need to register for you to enjoy protection. However, we do advise, there are some benefits to registration. Of course, once you register, you are able to produce, if there is an infringement or need arises, you are able to prove ownership. You can either use the work if you can be able to prove that you are the one who generated the work. Maybe you have time-stamped it in some other way. But a registration certificate from the Kenya Copyright Board, for example, would have a lot of weight to prove that you are the owner of it. So to answer the question, registration is not mandatory, but it is important. You can use the work if you can prove that it originated from you, but I do believe that registration gives you the
then,
yeah.
Okay, then a final question. In partnerships, for example, Ngamia, I would very much like to partner with MNOs like Safaricom, like Airtel. We are still in the small league, but we're getting there. How do we handle the copyright issues and ensure there's a balance in ownership? If it gets to that point, how would that look like for partnerships?
Yeah, in partnership, it's important. Of course, I'm sure you're aware to have them written down. And the best way to protect both sides is to have clear clauses that clearly expresses the rights, obligations, and the rights of each of the parties. Specifically say that copyright in the Ngamia mobile application shall remain the exclusive intellectual property of Ngamia. So it all boils down to the wording of the agreement. And again, in that agreement, ensure again that you have the non-disclosure clauses, where if, for example, Safaricom, of course, will have access to that app, and they can potentially get access to your source code. You provide a clause that requires that should that happen, then they shall not use it. And if they maybe commercialize it or without your consent, then liability falls on them. So Mona, it falls down to the wording of the agreement.
Okay, I know I have said finally 10 times, but I promise this is the last one. I think there was a lot of interest on copyright.
Yes, that's okay.
Yeah, so normally when guys go signing NDAs, how much weight does this hold? Because we sign a lot of NDAs with different companies. You probably don't get into an agreement with them. To what extent would this kind of a document help or get to you? Because like here at Ngamia, as an example, again, we have a lot of NDAs that we sit on with other companies that we've exchanged that kind of information with. So to what extent would that kind of a document help legally? Or is it
my
just,
response,
yes. Or is it just on the business front?
Okay.
Yes.
My response, my response to that would be the non-disclosure clause or the agreement is essential. Have it, but it doesn't work alone. It can't work alone. So you have to, for example, employ other ways. You have, for example, to register your copyright as evidence that that belongs to you. You have to employ such things as trade secrets. Don't disclose everything. For example, if you are, for example, pitching to a certain company, then the non-disclosure in itself may be there. But chances are, these guys may just be wanting you to just bring something to them and then they use it. So if you are pitching somewhere, carry your own laptop. Don't leave anything with them. Remain with them and go with it. And let them sign the non-disclosure. So the non-disclosure clause is not enough in itself.
Okay, so it's a supporting document. Okay.
Yes.
Thank you so much, Kaindo. That has been very insightful. I think many of us here, techies, entrepreneurs, had been wondering about these things, issues of trademark patents. I know we haven't had enough time because we are just 5 minutes from finishing. So for those of you who want to build a product, who want to build a company, who really need to know the subtle differences to be able to protect your investment, I hope this webinar has given you some basic knowledge. You could very well find yourself in the wrong end or losing end of the legal battle if you don't have some of this, if you avoid some of these things. So I want to thank our speakers today. I also want to just, in finishing, Muturi, I don't know whether you have something for us, and then Kaindo, and then I'll wrap this up for us, for our audience, so they can move on with their day. Muturi, any final words for the audience?
Thank you, the audience, for listening to us. I think the business of data collection is not going to be as usual. As our CS for health says, it's not going to be normal. It's going to be something different because with the enactment of the Data Protection Act of 2019, there's greater responsibility which is bestowed on those who protect data, and basically the rights to privacy as provided for under the Constitution in Article 31 has been given more accolade, and it is all in what information we collect, what we can share, by who, when, and how. Thank you, Mona.
Okay. Thank you, Muturi. Before you give us our final comments, there's a comment here from Rose Osemo. She's also legal counsel, very good friend and family of mine. So she says that the Kenya Copyright Board needs to engage in advocacy to ensure that IP holder who does not know that his innovation can be protected seeks legal protection and thus valid ownership. So that's a comment towards you because you're the legal counsel at Kekobo. So I don't know whether you want to react to that, but you could also react to it and then give us your final comments.
That would actually work very well as a closing remark. Thank you, Rose. It is actually true, but we do conduct a lot of advocacy at trainings on it. But of course, we can only do too much. That is depending on our pockets. Our pockets at Kekobo are not always so deep, so we struggle to do that. But we do what we can. So I think that's a valid comment from Rose. Thank you. Now, my closing remark is simply to thank you, to thank Ngamia, to thank you for hosting us. It has been great. I always find the time very limited. When I have a lot, I want to talk about a lot, but the time always catches up with me. I hope we are going to have more of these webinars in future. So thank you so very much, Mona and Ngamia, for having us.
Okay, thank you so much. So in closing, I just want to thank all our guests for making time to be with us this morning, if you're in the US and other areas, and this afternoon, if you're in Kenya and within the borders. So in the transport and logistics supply chain sector, there might be legal needs that are more glaring than intellectual property. In fact, it's very rare for a logistics and transport business to think about their intellectual property until a breach or a dispute arises, like both wakilis have said. So as in most things, this should not be the case. So we all need to get on top of our intellectual property assets while your business is still going well, while your business is growing. So don't wait for a dispute or a breach to happen before you act. So everybody who would be listening in, if you're in any sort of business that would need data protection, you need to sign up for an IP, feel free to reach out to us. We're going to put up a screen on how you can reach us at Ngamia. So I just want to thank you guys. We will be reaching out to you if you would be interested in webinars that we will be having moving forward. And yeah, I think it was a good one. Thank you, Muturi. Thank you, Kaindo, once again. And thank you to all our audience for joining in. Yeah, so thank you so much.
Thank you.
Asante sana. Bye-bye.
Asante sana. All right, goodbye. Thank you. Thank you, everybody.